Welcome to the ASCB webinar series. This webinar is on green cards for scientific researchers, how to win your EB-1 NIW case. My name is Sedella Blatch. I'm ASCB's Director for Professional Development. I'm going to introduce our speaker, Mr. Brian Getson. Mr. Getson is a graduate of the University of Pennsylvania Law School with 20 years of experience as a leading U.S. immigration lawyer. He represents scientific researchers applying for green cards and is the principal of a boutique immigration law firm based in Philadelphia, Pennsylvania. Mr. Getson has given presentations on green cards for scientific researchers at numerous major scientific conferences, the Wistar Institute, and at several universities. Mr. Getson often provides a money-back guarantee to qualified applicants. See his website, researchergreencard.com, for more information. And now I'm going to turn things over to Mr. Getson.
Very good. Thank you so much, Sidella, for having me, and thank you everybody for coming today to hear the presentation. So again, to give you a little bit of background about myself, I'm a graduate of University of Pennsylvania Law School, and I'm entering my 23rd year of practice. And I've authored a book on immigration called Obtaining a U.S. Visa Based on Achievement. And really my specialty is helping scientific researchers obtain green cards. And I'm actually going to be at the ASCB annual conference in San Diego. So I'll be at the career fair, and if anyone wants to speak individually one-on-one, please stop by and visit. And we also give free consultations year-round by telephone or Skype. And again, you could reach out to me at our website, Researcher Green Card. So there's really only one place to begin talking about immigration in the year 2018, and that is with President Trump. And you know what I want to tell everybody is that what I am going to talk about today has not changed. It's not going to change. The Immigration Service is still giving green cards on a regular basis to scientific researchers. And, you know, I know there's a lot of rumors and there's a lot of uncertainty and sometimes fear about what's going on. But, you know, what we are talking about in terms of the ability to obtain a green card, it still exists, and everybody should strive for that goal. So really what I want to do today is give an overview about, you know, the primary topics are, number one is I want everybody to have a plan about where they are right now and where they're headed. And then number two, I want everybody to understand what the Immigration Service is looking for when they decide to give a green card to a researcher, and then what you can do to improve your credentials to put yourself in the best possible position for approval. So again, you know, the focus of the president's policies is really to build a wall and to, you know, deport people that are criminals and are here unlawfully and secure the border. And what we say is that, you know, rock star scientists are still welcome in the United States in 2018. So the first thing to really think about is timing. And you have to consider that most of you listening right now, you're here in the United States in one of these three types of non-immigrant visas. There's the F1 student, the J1 postdoc, and the H1B visa. So you want to be able to maintain your underlying non-immigrant status for the amount of time it takes until you're in a position to file for a green card. And the ability to do that is a little bit different if you're from China or India than if you're from anywhere else in the world, because there's backlogs in every category right now for China and India. So you need to really focus on maintaining your non-immigrant status. And you also want to realize where you're going. So essentially, if you're in F1 status, you're going to have 3 years of optional practical training after you graduate. You're going to have a 24-month STEM extension that is after your initial 12 months of OPT. And the common way to go forward with a non-immigrant status if you're in an F1 visa is to go from F to OPT to H-1B. Now, you can apply for a green card out of any of these non-immigrant statuses. You can apply out of F, you can apply out of J, or you can apply out of H. Generally, I do not like applying for green cards for people who have not yet graduated. The Immigration Service likes to see plans for work in the United States in whatever category you're applying. So before you've graduated, it's usually not a good idea to be applying for a green card. Once you're in your OPT, then if you're qualified enough, and essentially you're not from China or India because you can't file a green card application with the backlogs right now, then you could consider applying for a green card out of your OPT. But you have to always think about, what is my plan if my green card application is not approved? How do I maintain my underlying non-immigrant status? So again, the non-immigrant statuses are F1, J1, H1B, and you could also try and maintain a non-immigrant status with an O1. So if you're going to be applying for an H1B at the end of your OPT, or if you're in J1 status and are looking to apply for an H1, there's a difference between the private sector and a university. Private sector, you have to go through what's called the visa lottery for H1Bs, and that is conducted April of each year for an October start date. And you have to win the lottery and have your case approved. So if after you graduate your F1 status, you're going to be in OPT and you're going to be in an industry situation, then you want to apply for an H1 visa lottery as soon as you can, even if it means cutting your OPT short. If you're going to be in a university situation, then you can use your full 3 years of OPT and not worry about the H-1B until the end of your OPT. And you have to, again, balance maintaining your underlying non-immigrant status with what is the right time to apply for a green card. And the right time to apply for a green card depends on your credentials. So if you're going to industry and you're going to stop publishing, then maybe you think about applying for a green card a little bit sooner than you would if you were in a university postdoc job where you're going to keep publishing and keep your credentials building. So again, the odds of winning the H1 lottery in industry is 1 or 3 and worse. This past April, there were 196,000 applications for 85,000 total visas. And it's 65,000 regular visas and 20,000 with U.S. Masters. And the year before, there were 237,000 applications. So again, we're talking about timing and managing a long-term plan. So if you're in F1 status and you're going to have 3 years of OPT, what are you going to do after that? And you're going to have to go one of 3 places. You're either going to have an H-1B, which is either going to be in industry subject to the cap or university cap exempt, or you have to go to a J1 status, and that can only be with a university with limited exceptions. You know, some companies have their own J1 programs, and then, or you have to go directly to a green card. So, you know, and I want everybody thinking about where are they going to go next from their existing non-immigrant status, and when is the right time to apply for a green card. And that really depends upon credentials and whether you have the ability to stay in non-immigrant status. So if you're in H-1B, you can get that for 3 years and it can be extended for another 3 years. And then that gives you, you know, a long time period to be able to build your credentials if you have to towards a green card. And again, H-1B status does not automatically result in a green card or permanent residence. And, the other non-immigrant category that you can apply for, if you're running out of time in a student status, or you're at the end of your 6 years of H1, or you're at the end of your 5 years of J, and you can't be sponsored for anything else, is an O1. And an O1 is an extraordinary ability alien visa, and it's similar to the green card EB-1A category. So there's two primary paths to a green card for a foreign national. The most common way that foreign nationals apply for green cards is through what's called a labor certification. And a labor certification involves having a U.S. employer sponsor you and demonstrating a lack of U.S. worker availability. But for everybody listening to this webinar right now, you want to try and avoid this labor certification. You want to try and get a green card based on your own research accomplishments. And there's three categories in which you can apply for a green card without regard to U.S. worker availability. It's the EB-1A extraordinary ability, EB-1B outstanding researchers and professors, and EB-2 national interest waiver. So the H-1B that lasts for 6 years, you can extend it beyond 6 years if you start a green card process more than a year in advance of the 6-year expiration, in which case you can extend your H-1 for 1 year, or if you have an approved I-140, then you can extend your H-1 for beyond 6 years. So in 3-year increments. And this ability to extend H beyond 6 years, it's important if you've waited close to the end of your H-1B to start thinking about a green card application. And it's also important if you're from China or India, where there's backlogs right now in the green card categories. So again, a labor certification, you have to have a U.S. employer sponsor you. And if there's a U.S. citizen or green card holder who meets the minimum qualifications, then there's you can't get a green card. So the focus of what we're talking about today is getting a green card while avoiding this labor certification requirement. So the first category that we're going to talk about is EB-1A extraordinary ability alien. And EB-1A is especially important for China and India due to the backlogs. So what I mean by backlogs is the Congress of the United States has allocated a certain number of employment-based immigration visas each year. And no one country can get any more than 28% of the total visas. And we're talking about these different levels of categories, EB-1, EB-2, and EB-3. And there's something called the Visa Bulletin, and that is issued by the State Department. And if you would just Google Visa Bulletin, you would see, what I'm talking about with these backlogs. There's dates for filing, and there's final action dates. And when the demand exceeds the supply, there becomes waiting lists. So right now, for the first time ever in history, when the government fiscal year started over on October 1st, there is a backlog now in EB-1A. And that backlog is for China and it's for India, and also for the first time ever, it's for the entire rest of the world. So when we talk about how long the backlogs are, for EB-2 China, where we're talking about an NIW, the backlog right now is 3.5 years. It's normally 4.5 years. And for India and EB-2, the backlog is approximately 9.5 years. So in EB-1, for China and India, the backlog right now is about 2 years. And for the rest of the world, for EB-1A, there's a backlog of about a year. So everybody from China and India should be thinking about applying for an EB-1A or an EB-1B to try and not wait as long for a green card. In the past, you didn't have to wait at all for China and India to apply for a green card in EB-1A. But now there is a backlog, but it's still better for China or India to apply for EB-1A. If you're not from China or India, I would not even consider an EB-1A at this point. I would only apply for an NIW. In the past, some people not from China or India tried to apply for EB-1A because they could get the green card faster. And there was some merit to that in the past because you could premium process in EB-1A or in EB-1B and have a quicker decision. And then you would get your green card faster. But now that there's a backlog for EB-1A, the premium processing is not doing you any good. And one of the changes under the Trump administration is that everybody applying for an employment-based green card has to be interviewed. So because of that interview, it takes a little bit longer to get the green card. So the takeaway is that it's going to wind up being faster for you if you're not from China or India to apply in the NIW category. And it's also easier. It's an easier legal standard to apply for NIW. So if you're not from China or India, don't think about EB-1A. You want to be thinking about NIW, which is for all other countries. So when I'm talking about a green card, getting a green card, it involves two parts. There's the I-140 petition, and that is the EB-1A, EB-1B, or NIW. And then there is the I-485 green card application. And those are two independent things. And there's some strategy that goes in to the decision in terms of how to file the I-485 green card application. So if you're from China or India right now, you cannot file the I-485 application at the same time as the I-140. But you still want to file that I-140 as soon as you're ready to do so, because the date you file establishes the priority date that you then compare against the visa bulletin. If you're not from China or India and you're applying in the NIW category, then you can file the I-485 in one of three ways. You can either file it at the same time as the I-140, you can file the I-140 first and wait for it to be approved before filing the I-485, or you can file the I-140 and then file the I-485 while it's still pending. So the strategy depends on a lot of things. If you're in F1 status or J1 status, then those are what's called non-immigrant intent visas, and you would likely want to just file the I-140 and then only file the 485 if the I-140 is approved. Because a non-immigrant visa means that if you file a 485 green card, that's contrary to the non-immigrant intent. If you're in H-1B status, then it's okay to file the 485 with the I-140 at the same time because that's a dual intent visa. And the other aspect with timing is there's something that's new under the Trump administration. It's now a year old, but it's still new compared to before, called the 90-day rule. And what this means is that if you enter the United States in a non-immigrant status like F1 or J1, you should not do anything contrary to that status within 90 days of entry. So I will not file an I-140 petition for somebody in F or J within 90 days of their last entry to the US. So again, we're managing timing, we're managing non-immigrant status, and we're thinking about when is the right time to apply for a green card. And that the answer to that question, it's a balance between your ability to keep your non-immigrant status and your credentials. Because if you don't have the credentials, it doesn't matter, you know, what the non-immigrant status is. You want to make sure that you feel confident about your case before you file. And, you know, we offer a money-back guarantee to, you know, our clients who we feel we have a very good chance is qualified to win the case. So now we're going to talk about the credentials. And we're going to start with the EB-1A case, but the evidence categories that we talk about in EB-1A, they are also applicable to EB-1B, and they're also applicable to NIW. So there's two ways to win an EB-1A case. The first way is receipt of a major internationally recognized award like the Nobel Prize. And my note is good luck with this method, because I have never once had a client who has won the Nobel Prize, and I never expect to have a client win the Nobel Prize. So the moral of the story is you don't need to win the Nobel Prize to get a green card. There's a second method, and this is to satisfy 3 of the following 10 evidence categories. The first category is a difficult category to meet. It's receipt of awards for excellence in the field. And these are awards that are national or international in scope and are open to anybody in the entire field. So this is not a young person award. It's not a researcher award. It's not a conference presentation award. It's not a travel award. It's not an early career award. It's an award where anybody in the field can apply, and you're selected based on your merits. So sometimes I see people make mistakes when they file on their own, where they try and meet this category by giving an award that doesn't count, and then it looks to immigration like you're trying to stretch your case. So this is something that you can control because you can apply for the award. The worst thing that happens is that you don't get it. The next category is membership in associations in the field. And this, again, has to be based on achievement. So it has to be an association where you're let in based on your accomplishments. So, for example, anybody can join the ASCB who is interested in cell biology. So being a member of the ASCB does not count. But if, for example, you're a member of the Royal Society of London, then that you can only get in based on your accomplishments. So again, this is something that you can control and you can apply for, but it's hard. So you should think about, are there any organizations in your specific type of research field that you have to be let in based on achievement and apply? Next is published material written by other people about you. So this is not what you're publishing, but what other people are writing about your work. And generally, this would be you're mentioned in a book chapter, or there's a review article that prominently discusses your work. But most common, this is where there's some sort of media or news article written about you. You know, if you would go to Science Daily and you would just look at their homepage, you would see a bunch of articles about, groundbreaking scientific research. And I always tell my clients, read the article, and somebody's name is going to be in that article. And if I were representing that person for a green card application, I would give that article to immigration. So every university where you are at has a news media office or a press release office. So there's no harm in, if you have a groundbreaking publication, to go into the media office and ask them if they can do a press release on your work, or if they can, have a journalist talk to you and to include your name in the press release. And I always tell my clients it's free to ask. There's no harm in asking if somebody can do something. The worst thing that happens is they say no. So this is something that's really helpful to any type of green card application. And, just see if you can get somebody to talk about your work in the media or elsewhere and to mention your name. So now we're going to talk about the 3 most common categories of the 3 out of 10 that you have to meet. So the first is judging the work of others, and this involves doing peer review. So this is doing peer review in your own name, not for your supervisor. And the more you do, the better. 5 peer review is better than 3, 7 is better than 5, 10 is better than 7. With everything in immigration, quantity seems to matter more to the immigration service than quality. So, if you do peer reviews, it doesn't have to be for Nature. You just want to do it for whatever journal you can and do as many as you can. And if you're able to be on the editorial level, that is very helpful. So again, you should be your own advocate in trying to do peer review. You should email the journals and ask them, or call the journals, how do you get to do peer review? Try and have your supervisor help you to, with any contacts that could get you to do peer review. When you go to a conference, there in the exhibit hall, there's always journals exhibiting, and you can ask them how to do peer review. So, this is something that helps a green card case and doesn't necessarily help your overall career, but it's something I strongly urge all of you to do, is do as much peer review as possible. The next category is used in every single case, and this is original scientific contributions of major significance to the field. And what immigration is looking for is, how has your work impacted the field as a whole? And the primary evidence that you give for this category is reference letters. And when we submit a case, we're looking to submit 3 different types of reference letters. The first type is what I call independent reference letters. And I'm usually looking to have my clients obtain 5 of these letters, maybe 3 from in the United States and 2 from outside, or the other way around. And what I mean by independent is the person has never worked or gone to school where you have worked or gone to school, and they are not a co-author on your publication. They're independent. They may not even know you, but they know about your work. And how do you find these people? You network and you ask. Who has cited your papers? Who has reached out to you? Who do your supervisors and colleagues know? Who have you met at a conference? And I like to have these 5 letters talk about your entire career accomplishments. Some lawyers have the 5 authors talk about 5 different topics. But in my opinion, that's not as effective, because if you're only having one author talk about one topic, immigration could say, well, how come the author doesn't know about the other topics? So I like to have these 5 authors talk about everything. And then the second set of letters is letters from your supervisors. But those letters are not all that important. If you had the lawyer in the office next to me write a letter about me, you would expect that letter to say I'm a great lawyer. You would not expect it to say I'm terrible. So that's why there's a place for your supervisor letters, but it's not, given much weight by immigration. And then the third set of letters is what we call supplemental letters. And those are short letters, and that's trying to show any practical impact of your work on the field. And that's what, this slide that's up there right now is about that. So if you have a commercially viable patent, then maybe you get a letter from the company that's licensing the patent, or you get a letter from your university patent office, or you get a letter from a patent lawyer talking about the importance of your patent. Your work being used. If you have collaborated with any company that is interested in or using your work, then a short letter from the company carries a lot of weight with immigration. If a government agency is interested in your work, then a letter from the government agency really, really helps. I've had letters from the USDA, from NASA, from the Army, from the CDC, from the FDA. The only government agency that will not provide a letter is the NIH, but again, it's free to ask. And if you get a letter from a government, then I can say to the Immigration Service, hey, there's another government agency that's really interested in this individual's research accomplishments, and they give that a lot of weight. If you've given a conference presentation, if you have given an oral presentation or a keynote address, then you would maybe want to get a letter from the conference why they asked you to do that presentation. So before I talk about the next thing, the number one thing that immigration looks at with original scientific contributions is level of citation. So whether that's right or wrong, whether it's fair or not, that's what immigration looks at the most. So we generally base our money back guarantees off of level of citation. How many citations do you need to be approved? There is no answer to that question. The more, the better. For an EB-1A case, I like to see about 300 citations, but we've certainly had plenty of cases approved with a lower number of citations than that in EB-1A. With NIW, I like to see 75 to 100. But, you know, sometimes people work in fields that are not highly cited, and then we can explain that to immigration. For example, I did a case for a person who was conducting research in agriculture, and the nature of her research was to help make soil more productive to grow crops. And this was not really a field that was highly cited. Her work was more for practical use with farmers than it was for, you know, academic citation. So what I did was I got letters from farmers talking about how her work helped their crop production. And then she had also worked with the USDA, and I got a letter from them, which is the Department of Agriculture, and NASA was interested in her research because they were trying to help use it to grow food in outer space. So even though she had a low number of citations, her case was an EB-1A, and we were able to get it approved by showing the impact of her work in other ways. So everybody's case is unique, but that being said, the higher your level of citation, the better your chance for approval. And when we talk about timing and when to file, if you're in a situation where you know your citation level is going to go up a lot in the next 6 months, the next 9 months, and you have that time in your non-immigrant status because you're either publishing new or the trend of your citation level is upwards, then it could make sense to wait in order to file your case. So there's a lot of factors that go into the decision making of filing, and there's a lot of creativity that you can have in preparing the case. And when it comes to writing letters, my firm writes the letters for you. The way it works is you would outline your research, and after you would outline your research, I would ask you questions to try and simplify your research. Because the immigration officer is not a scientist, and I am not a scientist, and if I looked at any of your CVs, there would be terms on there I do not understand, and the reference letters are not journal articles. So you really want to be persuasive to immigration in terms of explaining your science in simple terms, and then also showing the impact of your work on the field. And just as a tip, when people come to me where they either did it by themselves or used other lawyers, the most common thing that I see that leads to denials is letters that are speculative in nature, where they say, you know, such and such research accomplishment, it may, you know, help treat cancer, or it may lead to this material. Immigration has no interest in what may happen in the future. And any type of speculative language can be used against you by the Immigration Service. Immigration only cares about what has already been accomplished by you. So you want to, at all costs, avoid words like possible, may, might, things like that in reference letters. The next category we're going to talk about is authorship of publications in the field. And again, this is something that nearly everybody meets, and more is better. You know, just as much as you can publish, do it. The level of the journal doesn't matter so much. I just want to see more publications, and then more publications leads to more citations. And again, when it comes to citations, you know, over 100 is best. For an EB-1A, 300 is best, but we'll certainly do cases with lower than that. And you can get any case approved at 50 to 100. If you're less than 50, it's possible but difficult, and we would analyze everybody's case on a case-by-case basis. Next category is display of work at artistic exhibitions or showcases, which doesn't apply to researchers. And then this next category is performing in a leading or critical role for organizations with a distinguished reputation. So again, with EB-1A, you're having to meet at least 3 categories. We've talked about the 3 most common, which are peer review, original contributions, and publications. I always like to file a case if I can with more than 3 categories, 4 to meet 3, 5 to meet 3, whatever it may be. So the next common category after the main 3 is usually media discussion, and then we look to critical role. And what this means is if you have done something for your company or university that sets you apart and is important to the overall outcome of the organization, then we would try and meet this category. For example, have you helped receive funding in your own name for your university? Is a company relying on your research for drug development? Do you have a patent that's bringing the university or a company money? Are you, training other researchers? Are they using your methods? Are you collaborating with people that brings prestige to the university? So that's what a critical role means. And a leading role is basically on job title. So if you're in a, your OPT or you're in a postdoc, you're probably not going to be playing a leading role. And then we have high salary in the field compared to others. And again, this is usually not the case for researchers. And then the other one is also a commercial success, which doesn't apply to researchers. So those are the EB-1A categories. And again, you want to think about what can you do to make your case stronger. You have no control over citation level, but you do have some control maybe over doing peer reviews, over getting your work talked about in media, things like that. So the O1 non-immigrant visa, this is the temporary version of EB-1A. And again, it's receiving an international prize or award or meeting 3 categories. And the difference between EB-1A and O1 is that EB-1A is a green card and O1 is only temporary. And EB-1A has a higher standard. And what that means is we've talked about meeting 3 categories. With the O1, if you meet 3 categories, you're done, your case is approved. With EB-1A, even if you meet the 3 categories, then immigration can still deny your case if they feel you are not at the top of the field by what's called a preponderance of the evidence. So there's this extra level of analysis that goes into an EB-1A case, and we talk about that in the cover letter that we present to immigration. And generally right now, O1 is an effective strategy in the following areas. Number 1, if you're working for a private company and you did not win the H-1B lottery, then O1 would be something that you could do at the end of your OPT. Or if you're finishing up your J and you want to go to O1, then you can still do O1 after your J, and you don't need to worry about the H1 lottery. And let me just touch on the J a second. A lot of J1s are what's known as being subject to the 2-year home residency requirement. And what that means is that you cannot get H-1B status or a green card unless you either go back to your home country for 2 years or you get a waiver of that 2-year requirement. You can still hold O1 even if you're subject to the 2-year home residency requirement. But for those of you who are in J1 right now and you're subject to the 2-year residency requirement and you want to get a green card, you have to get a waiver of that first before you can get a green card. So also, once you get the waiver, you can no longer extend your J1. So most people extend their J1 and then apply for the waiver as soon as they can. And you want to have a plan in place to be able to go somewhere after your J1 is done because you can't extend it. And the best way is usually if your university will sponsor you for H1 status. But again, you can apply for the I-485 right out of J1 status if you had to. So again, these are, everybody's case is different. Everyone has different credentials. Everyone has different timing. Everyone has different non-immigrant status. Some people have spouses that need to work. or that you're not living together because of your immigration situation. So, everybody's case is unique in terms of, how to manage it. EB-1B is outstanding professors and researchers. Again, this is really only relevant right now if you're from China or India. And if you can do EB-1B instead of EB-1A, then it's better because it's a little bit easier to get approved in EB-1B. EB-1B, there are the following criterion to get the green card. You have to have international recognition as outstanding. You have to have a qualifying employment offer, which is, I'm going to talk about in a minute, and you have to have at least 3 years of teaching or research in the field. So it has to be, for the employment offer, it has to be a tenure or tenure track teaching position, a permanent research position at a university, and that is above a postdoc. It has to be a research assistant or associate position. Or if you're in a private company, it has to be a permanent research position, and there has to be at least 3 other researchers besides you working in your department, division, or organization. And that organization, department, or division has to be recognized as having outstanding research achievements. And for the 3 years of experience, you can do it at the PhD level, count the experience, but only if your work was recognized as outstanding. So EB-1B has to be sponsored by an employer. You cannot self-file, unlike EB-1A and NIW, where you can self-file. So now moving on to NIW, you have to have an advanced degree, which all of you do, and you have to demonstrate that your employment is in the national interest. And the legal standard for NIW is what's in a decision called Matter of Dhanasar. And the Immigration Service is looking for 3 things. Number 1 is whether your work is of substantial merit and national importance. Number 2 is that you're well positioned to advance the proposed endeavor. And this is why I like you to have a job and not apply when you're in F1 status before you graduate. And if you're overseas, then you would also want some type of job or plans for work, whether you're applying for an NIW or an EB-1A. You can apply based on your word if you're overseas, but I really don't like to do that. I like to have some sort of at least a job intent letter about your job. If you're already in the United States, and then you're already going to be working, and you basically just tell the Immigration Service, hey, if you give me a green card, I'm going to continue working with my current job. And if I change jobs, then I will still continue working in my field. So when you're defining your field of research for any of these cases, it's very important. You don't want to say you're a researcher in the field of cell biology. That is a really, really big field, and it's hard to show you've influenced it. You want to try and narrow down your research field, like you're a researcher in the field of understanding the molecular mechanisms of cardiovascular disease, something like that, where it becomes smaller. And then you want to make sure you define your field in a way that it covers everything you've ever done, and it covers what you might do in a future job. And sometimes people change their research focus after their PhD. Maybe you focus on cardiovascular disease at your PhD, and then maybe you're focusing on cancer in your postdoc. So you can't just define your field as cancer, or you won't be able to count your PhD research. So we work with our clients to define the field in such a way that it covers everything you've done. And there's always a way to find a common theme of your research that it covers everything. Then the third NIW factor is, on balance, it's beneficial to waive the perm labor certification requirement. So again, what have you accomplished? Why is it important? How has it influenced the field? And why is it that the government should not care about U.S. workers because of what you've accomplished? And, for the NIW, there's no evidence rules. You just give whatever you want to make your case. But again, you follow along to those 10 categories that we talked about earlier. So national importance means benefiting the U.S. and, all of your research is going to benefit one of these things. It's going to benefit healthcare, the economy, the environment. Those are the main ones. So really what an NIW comes down to is showing that your accomplishments on balance justify foregoing the labor certification. And, you know, we're not using terms anymore like record of success and influence on the field. So premium processing is only available for EB-1A and EB-1B and not NIW. But, you know, right now with the EB-1A and EB-1B backlog, there's really no point in premium processing even for them. So even if you're from China or India and you're applying an EB-1A or EB-1B, it doesn't do you any good to get an approved petition if you still can't file for your green card for 2 years. So, you know, premium processing immigration tends to be a little bit harder in deciding the cases. So really where we stand today, there's not much point in premium processing at all. So some post-filing issues is, again, if you're self-filing an EB-1A or NIW, you can change jobs, and as long as you stay in your same field, it's not going to affect your green card. You're either going to change jobs by changing your non-immigrant status, either by getting a different J-1 employer or changing your OPT job or getting an H-1B change of employer, or you'll have a EAD based on your 485 and you'll change jobs. And with EB-1B, you can only change jobs after your green card has been pending for 180 days, and it has to be in a same or similar position. And, you know, what's new is what might be gone, and that's H-4 work authorization. The Trump administration has talked about for quite some time taking away H-4 EADs. So this is mostly for China and India, your spouses, when you're in the backlog. And, you know, until it happens, there's not much you can do other than keep applying. And we don't think that they will take away any existing H-4s. But again, we're not sure, you know, if and when this is going to come. And then with entrepreneurs, you know, there was talk about having an entrepreneur green card, but that's really been shelved right now. So, you know, what our firm does for our clients, you know, we already talked about the money back guarantee. And again, we usually base that on citation level, but we look at other things as well. And the fees and costs for the case are set forth on our website. Generally, we charge $5,000 for the I-140 petition and $100 for costs. And then for the green card, it's $1,000 for the principal and $600 for each dependent. And we would return the $5,000 if your case is not approved. So, you know, your risk is basically the filing fees and the cost. And then we have a team of science writers in-house that all have basically master's level degrees in a science area, and they help to draft the letters because they're able to understand the experience, the type of research that you're doing. And then, you know, I've been doing this a long time, so I've seen a lot of immigration decisions. I prepared hundreds and hundreds and hundreds of cases, so, you know, we really have a good sense of how to put a case together. So, and, you know, we've also talked about how we write the letters. And we'll also help you get ideas about, you know, the type of evidence and letters that you can obtain in support of your case. So, again, my website is researchergreencard.com, and there's a way to do online scheduling for a consultation, or you can send me an email or fill out a contact us form. And again, I'll be at the ASCB conference in December in San Diego at the career fair, and we'll be giving another talk, you know, similar to this, but I'll vary it a little bit. And then, you know, I'm happy to speak with you individually about your case at any time. So now I'm going to answer some questions that have been asked. And, you know, if you have any questions right now, feel free to type them into the Q&A. So the first question is, can Indians not apply for EB-1 category right now? The answer to that is, you know, Indians can apply for EB-1 right now, and same with China, and same with anybody. Again, there's the I-140 and the I-485. Everyone from India and China can file the I-140 right now, and you should if you're qualified to establish the date, but you cannot file the 45 until the date becomes current in the visa bulletin. So you have to manage your underlying non-immigrant status so that you can stay in the U.S. legally working until you're able to file the 45. And that's the case right now, whether if you're from India or China for an NIW or an EB-1. The next question is China or India nationality based on your place of birth or country of citizenship? The answer is your place of birth. But if your spouse was born in a country other than China or India, then you can use their place of birth. For citations, is the citation number based on overall citations or first author papers only? The answer is overall citations. And to elaborate on that, even if you're not first author on your paper, you can still call it your own research. There is case law from the Immigration Service that says if you have published, you can say, Dr. So-and-so discovered this, even if you're the fourth author. So in your letters, you never want to have the word team or collaboration, because there's law that says if you did the research on the publication, you can say you discovered it. Can you apply for O1 and then to green card? Absolutely, yes. O1 is a quasi non-immigrant intent visa. So if you have an I-140, you can still freely travel and get an O1 visa or extension. But once you file the I-45, you cannot extend the O1. Next question. I don't have the 2-year return rule for my J1. Can I apply for a green card directly from J1 or J2? The answer is 100% yes. And again, you're going to manage your timing where you're going to file for the I-45 green card application. But you might not want to do that. You might want to just file the I-140 first when you're in J1, and then file the 45 if it gets approved. And that's what I normally do for people in J1. So do I have money back guarantee for all my clients or just the ones I think will get approved? The answer to that is only the ones that I feel very confident will get approved. I would be out of business if I gave a money back guarantee to anybody who came along. Is working in a federal government lab for 3 years make you eligible for EB-1B? The answer is yes, but the government lab has to sponsor you for a permanent research position, and you have to be otherwise qualified for EB-1B. When should I apply for my 2-year residency requirement waiver? I'm currently on a J1, which ends in 2020. Well, if the 2020 is the end of your 5 years of J1, then you should be applying for the waiver right now. If 2020 is only at the end of your 2nd year, then you would have to see, well, what country are you from and what are your credentials? Where do you want to apply for the waiver now and maybe go to H and apply for the green card, or do you just want to wait a little bit longer? So, somebody who is a PhD candidate and, they only have a certain number of publications and they're going to industry. So, that you have to balance when you're going to file. If you're going to industry and you're not going to continue publishing and presenting and getting higher citations, then maybe you file a little bit earlier than you otherwise would. So you have to analyze the timing for file based on your own unique circumstances. Next question, do you only submit applications for STEM or also social scientists? Is it the same process standards? The answer is anybody can qualify for EB-1 or NIW. It's not just STEM scientists. It can be any field, and it is the same process and the same standards. I'm marrying someone who already has an EB-1A green card. Does it make me eligible? The answer is no. If the person already has a green card, then they could sponsor you. So, when it comes to marriage, if you're marrying a U.S. citizen, forget about everything you just listened to me say in the last hour and apply for the green card based upon marriage. If you're marrying a green card holder, there's a wait of about 2.5 years, and you should probably have the green card holder sponsor you, and then you'd have to manage your non-immigrant status for that period of time. As an Indian student, can I apply for NIW? The answer is that's probably not a good idea because the wait is 9.5 years, and just having an I-140 petition does not give you any right to live and work in the United States. So normally I'm only applying for an NIW for Indian if you're in H-1B already. And that might also be the case now for EB-1. You know, we would apply for China and India EB-1 sometimes out of student status, even though that's hard, because if you're an early career researcher, it's hard to show you're at the top of the field in the world, no matter what your credentials. But now, if you're from China or India with these weights, you really need to start thinking about how can you get to H1. And if you need to go to J to bridge to H1, then so be it. Is there a website tool you use to count citations? The answer is Google Scholar. That's what immigration uses, and that's what we use. If you miss H1 status while your green card application is pending, then we're talking about a 485. You have a pending green card application. Another question about citations and being first author. There's no rule. You can, it doesn't matter. Your citations are your total citations no matter what. For NIW, there are no set evidence criteria. It doesn't matter how many, categories you have. There are no categories. If you're working for the government, does it help your case? Yes, because you can tell the Immigration Service you're working for a government entity and they like that. But if you're not otherwise qualified with publications and citations and other things, then you're not going to get your case approved. And again, NIW, you're doing similar things to EB-1A. You're giving the same type of evidence with citations and publications and peer review. It's just the standard is easier to meet. So immigration's analyzing you off of an easier standard, which is why it's easier to get a NIW approved. Can you apply for H-1B out of J-2 status? The answer is yes, as long as you're not subject to your principal is not subject to the 2-year residency requirement. As a PhD, do I recommend a postdoc rather than an industrial position? I always tell people you do what's best for your life and your career, and you let the green card follow. So, if you want to do an industry job, do it and then figure it out. If you go to postdoc, you're able to publish more and build your credentials more, but I would not want the green card to be a factor in how you choose your career. Because if you go to a postdoc and it's not approved, then you should have gone to industry. So just let your career dictate how to go. Okay, so there's too many questions for me to get to them all because we're at the end of the hour. So again, I'm more than happy to talk to anybody individually throughout the year. If you email me or schedule a consultation by telephone or Skype or answer our contact page or come visit me at the conference. So thank you all so much for attending. I really appreciate it. And again, I want you to be positive and encouraged about getting a green card in the United States. The laws are not changing with this. And, you can certainly, if your goal is to live and work in the US, then you can work towards meeting that goal and getting a green card.
All right. Thank you, Mr. Getson. That was extremely informative. We really appreciate all the information you shared and taking the time to answer questions as well. Everyone has the website here, so you know how you can reach out for more information and the consultations, as Mr. Getson said, and look for him at our meeting in December in San Diego, which we hope you all are attending. And we will email a recording of this to everyone who registered, and it'll also be available on our website. So you'll have the information there. So thank you so much, Mr. Getson. We really appreciate this. And we look forward to seeing all of you, including you, Mr. Getson, at our meeting in December. So thank you guys so much and have a great day.